Okay, thanks everybody. So welcome to Navigating the Small Business Administration and the Department of Veterans Affairs Small Business Programs. In particular, we're going to be really focusing in on the SBA's SDVOSB program and the VA's SDVOSB and VOSB programs. And we're going to talk about the differences, both in the regulations and the law, as well as policy differences that you won't see if you just look at the Federal Register notices or the regulations themselves. So hopefully that'll give a little bit more insight on how things are really operating on the ground level. Let's go forward. My name is Alba. I'm a partner in the Government Contracts Group, and I'm here with my colleague, Alex.
Hello, everyone.
And we're going to be kind of tag teaming this event here. I'm going to be starting off talking about the Small Business Administration's program, and that's going to be the general overview of all the rules that apply both to SBA and VA, and then Alex will take over and start discussing the VA-specific regulations and policies that are a little bit different and that can get you tripped up if you're going after VA procurements. So without further ado, like I said, this is an overview. We're going through a few things. You can see the slide, and let's just get into the meat. All right, so when you're talking about SBA's Service-Able Veteran-Owned Small Business Program, these are the general requirements for both SBA and VA. The Service-Able Veteran-Owned company must be a small business. Now, for SBA, that is on a contract-by-contract basis. So depending on what contract you're bidding on, the NAICS code assigned to that contract will be what is applicable to you. That's also true for the NAICS code assigned to task orders. We're not going to get into a lot of detail, but SBA issued a new rule on multiple award contracts, which includes federal supply schedules. And the NAICS codes now will likely, if the COs do it correctly, be done on a task order by task order basis, generally speaking. And so you'll have to be small under the NAICS code assigned to that task order. In addition, for all programs, the veteran owner, whether it's a SDVOSB for SBA or SDVO/VO for VA, the veteran owner must have a service-connected disability as determined by the VA or DOD. Also, a big deal, the company must be unconditionally and directly owned by the service-disabled veteran. That's something that people can get tripped up on, and so we'll go into more detail on that later. Let's see, and I actually have a question generally on about if you merge a service-able veteran-owned business with another business, do you have to subsume the business, or it can be a division of the larger company? And it can be a division. It can also be a subsidiary. However, you have to remember the subsidiary itself cannot be an SDVOSB company, or won't be eligible. Only the parent company in that example would be eligible, because the subsidiary is not directly owned by the service-abled veteran. It's owned through the parent company. Now, that said, and we were going to get into this a little bit later, but I'll just say it now, any work that is done by that subsidiary company will count as work for the SDV, him or herself. So if it says you have to devote full time to the business, if you're managing, or if you have to devote a substantial time, any work you're performing for that subsidiary, the wholly owned subsidiary, will count to meet those regulatory requirements for the parent company. Okay, so with the service-able veteran, you have to own at least 51% of the company. Most people know that. The ownership has to be direct, which means it can't be through any other company. You can't have a holding company and then have a service-able veteran eligible subsidiary. That just won't work. The veteran has to hold it directly. It can be held in a trust. The trust has to be revocable, and the service-able veteran has to be the grantor, trustee, and the current beneficiary of the trust. That's becoming more and more common, I think, for a lot of estate planning purposes, and so that's just something to keep in mind. The service-able veteran has to have unconditional ownership, right? So that means a variety of things depending on your company name, your company type. So if you're a partnership, you have to meet the requirements that at least 51% of every class of partnership interests unconditionally owned by one or more of the service-able veterans. The ownership must be reflected in the partnership agreement. So that's something where a lot of times people might not discuss what types of interests there are, and we suggest people be explicit, even if it's a partnership, so that everyone make clear that every class of the ownership is a single class, or if you do have multiple classes, then it has to be spelled out clearly, so that whether it's the VA or SBA reviewing these types of things, that none of them believe you have some unknown classes of either if it's stock if it's a corporation or ownership interest if it's a partnership or an LLC, which would give one person more control than another. So you just have to be explicit that you are clearly controlling 51% and that any classes of stock or ownership interest that has voting rights or other powers is completely controlled, 51% at least, by the veteran. If you're an LLC, same thing. Make sure it's not conditional. Make sure there are very, very limited supermajority voting requirements, if any. In a perfect world, you wouldn't have any, and the service-able veteran would control everything. However, in limited circumstances, there are supermajority requirements allowed, like adding, removing members to an LLC, for instance. Those are areas where, at least in the SBA context, the rules are getting a little bit less stringent as the Office of Hearings and Appeals at SBA realizes that real businesses have real interests to control, and that in order to get investors, some of these rules have to be relaxed a little bit, so that's good news for everyone. With regard to a corporation, you just have to make sure that all of the outstanding stock and 51% of all the voting stock is held by the service-able veteran. And I think we've got a couple questions. Yes, we had someone ask whether the service-able veteran-owned parent could claim the past experience of a subsidiary, and the answer there is yes. The subsidiary should be wholly owned by the service-able veteran small business company, and if it is wholly owned, there's some GAO cases that suggest you could use that past performance and experience as your own, especially if the subsidiary is performing some work or providing some assistance on the contract. So if you wanted to be completely safe, you'd have your subsidiary performing some services and some work in order to make sure you can count that experience as your own. Go on to the next one. All right, so then who controls a service-able veteran-owned small business? To be eligible, you have to manage the day-to-day operations of the business. The service-able veteran, him or herself, has to manage those day-to-day operations. You have to hold the highest officer position, and the key thing here is that you have to actually have managerial experience and at least some modicum of knowledge over what the business is actually doing. Now, you don't need to have all the technical expertise or licenses if there's some electrical license or something like that required. You don't necessarily have to have that. Your employees can. But both the SBA and the VA are really looking now at whether or not the veteran owner has enough knowledge of the subject matter to adequately manage the company. Now, for instance, if you're a construction company, and this is a real-world case, and the service-able veteran, let's say, came out of Vietnam, started cutting hair, ran a hair salon, and did a great job with the hair salon, but then started a construction company, the VA and SBA will likely frown upon that because the veteran owner doesn't have any actual experience with the subject matter of running a construction company. And so that's something where we've seen people run into serious problems, including debarment proceedings and things like that, with the VA in particular, because they did not have enough technical expertise to understand, in a VA's opinion, how to manage the company. So just keep that in mind. While you don't have to have the technical expertise or the licenses, you should have some modicum of knowledge about the actual business you're doing such that it would allow you to manage effectively. Okay, in the case of a partnership, remember the veteran has to be the general partner with control over everything. And in an LLC, that's probably the strictest area here. The LLC has to be completely controlled. Every single decision has to be controlled by the veteran, service-able veteran owner. And so in the case of an LLC, what I said earlier about certain supermajority voting requirements and things being allowed, in the LLC context, it's much more strict. And so if you want to qualify and pass muster through everything here, the veteran needs to have complete and total control over the LLC. In the case of a corporation, things get a little bit trickier, especially in the VA context, where I think Alex will touch on later. But for SBA, the service-able veteran has to control the board of directors, right? So what does that actually mean? Well, in the SBA's context, it doesn't necessarily mean that the veteran has to have more votes at the board of director level than anyone else. So let's say you have a board of 3 individuals, and the veteran is one person on the board, and there are 2 other individuals on the board. That looks like the veteran has 1 vote, and non-veterans have 2 votes in this example. So anything the veteran did at the board director level, he or she could essentially be vetoed by the non-veteran directors. And while that's true, SBA, rightly so I think, takes a more macro level, and they're going to look at how the company is actually run. So if at the corporate level, the service-able veteran has 51% or 60% or something of the ownership interest, and that percentage, say it's 51% ownership interest, is enough to add or remove any board member at any time and create a quorum and do shareholder votes and everything, then SBA is going to look at that and say, okay, sure, there are 2 non-veteran board members who could veto the veteran at the board level, but then the veteran, owning 51% of the stock, could turn around and immediately remove those board members and appoint 2 new members, or simply remove them, be the sole board member, and hold a special meeting in order to reverse whatever those board members just did. So in the SBA context, that's good. It gives you more freedom in how you're going to structure your company, and it also allows you to maybe throw a bone to some non-veteran owners in order to get them comfortable investing in your company or otherwise becoming owners and providing necessary skills and services to your company. So that's just something to keep in mind. It's different for the VA, maybe not on paper, but policy, it's a little different, so we'll get into that later, so stay tuned. Joint ventures. This is becoming more and more popular, especially given the rise in multiple award contracts and what some people would call bundled requirements. And so here, SDVOSBs can enter into a joint venture with any small businesses in order to perform a service-disabled veteran-owned contract, so long as the service-disabled veteran-owned member holds 51% or more of the ownership interest in the joint venture. So unlike with HubZone, the service-disabled veteran, in the service-disabled veteran world, you don't need to form joint ventures with only other service-disabled veteran-owned companies. You can form with any company, including large businesses if you're in a mentor-protege arrangement. Now, the important thing to note there, however, is that currently there is no approved service-disabled veteran-owned small business mentor-protege program. There are some out there, including with the VA, but SBA's view in that world now is that unless the SBA approves the program, then they will not view the program as giving you some exception from affiliation. So currently there are only 2 mentor-protege programs that fall under the exception, and that is the 8A program, which is run by the SBA, and it is the DOD's mentor-protege program. Any other program, including VA, currently, as far as we know, does not have exemption status because it has not been approved by the Small Business Administration. There's been a lot of pushback from agencies because they feel that the SBA is overstepping their bounds in forcing approval of these programs. and the SBA takes the opposite view and says, no, this is exactly what their job is. Now that is important because if you are protested, a size protest, if a size protest is filed against you, or in the case of non-VA procurements, if a SDVO challenge is filed against you, the SBA will be the agency making the determination on whether you're small or whether you qualify. And so if they don't think that your mentor protege program gives you an exemption from affiliation, that's bad news. Someone asked about, is there a DoD mentor protege program for SDVOs? There isn't. I should clarify that. The DoD mentor protege program, there's nothing new about it. It's the same old DoD mentor protege program that they've always had. It is not particularly for SDVOs or VOSBs. Just in a general sense, I was just stating that the only programs that will give you an exemption from affiliation are 8A or the DoD program. No other programs. Now, what's interesting about that question, however, is that SBA is looking into new mentor protege programs. Under the National Defense Authorization Act of 2013, Congress and the President authorized SBA to create new mentor protege programs. We expect those regulations to be released later this year, probably in the distant future, though, maybe this summer, if not later, in the proposed rule format with final rules to follow. And we're hoping that a lot of these programs, especially for SDVOSBs, will mirror the 8A program in a lot of respects and will give you, hopefully, a exemption from affiliation so that you can then enter into mentor protege agreements once these rules become final with large companies as an SDVO, and you can take advantage of whatever rules and benefits the SBA creates. But currently, there are no proposed rules and there are no final rules on that. So anything that anyone tells you is pure speculation. And our contacts with an SBA have told us that they're working on them. They've revised them multiple times, but that they are still at the SBA and there's no ETA on when they will be released. Let's see here. A couple other questions I want to get to. So someone asked, is there an SDVO JV template that meets SBA's criteria available through SBA? The answer to that is yes and no. There are JV templates that are available on SBA's website. However, we've had people get in trouble with those because you cannot rely upon anything you get from any government website or anything that any government employee that's below the secretary level or the president tells you. Anything else is just advice that you should take with a grain of salt, and you cannot rely upon any of it. So be very careful when using templates, because even the SBA in a recent case said that an individual who tried to use a template that didn't have all the requirements in it, they were found to be other than small and ineligible, even though they used an SBA template. And essentially, SBA apologized, or the Office of Hearings and Appeals told SBA that they should get their act together, but it didn't change the fact that they were other than small because they relied upon an incorrect form. Another clarification someone asked, with the VA SDVOSB contracts, can you have a joint venture that is not two serviceable veteran-owned companies? And we'll get into some of the differences of that program later, but yes. So long as you meet the other requirements for a joint venture under the VA and SBA, which, if we go down the slide here, it says, where we say a joint venture of at least one SDVO, SBC, and other businesses can submit an offer so long as a small business is for a competitive set-aside. Those sub-bullets right there is really the key part. So the procurement itself, if it has a revenue-based size standard, the procurement must exceed half of the corresponding size standard, right? Or if it's an employee-based size standard, it has to be a contract of greater than $10 million. So long as you meet those requirements, and so long as all members of the joint venture are small businesses, then if the SDVO can take a 51% ownership interest, and any number of other small businesses SDVO hub zone 8A, woman-owned, doesn't matter, can make up the other 49%. And as long as you structure it correctly, you will be eligible. And that's SBA or the VA. We'll get to that stuff later. And then at the end here, someone asked about this parenthetical we have about no internal performance of work requirements. That's an interesting anomaly, I think, with the SDVOSB program at SBA. And essentially, if you look at the regulations, there are rules about the work split between the joint venture and any subcontractors, meaning if you have a contract that you're bidding on as a joint venture, the joint venture itself has to do 51% of the work. The other 49% can be this is for services. The other 49% can be subcontracted to a large business or other small businesses without any real problem. However, what work split has to be developed within the joint venture? And that's where there are no rules under the SBA's program. There are for 8A, but for SDVOSBs, there are none. So in theory, the service-disabled veteran member of a joint venture could do 0 work, and the non-service-disabled veteran members could do 100% of the work, and you'd still fit within the black letter law of the SBA regulations. Now, clearly, that's not what was intended, but it's something to take note of, especially if you're in a joint venture or it's like you're not a service-disabled veteran company, you're teaming with one. That would give you a little bit more leeway, potentially, to do more work within the joint venture than you would otherwise be able to do. But I'd be careful about getting too crazy with that because, A, I think it was a mistake, and SBA will either fix it or they'll say something like, well, you should have known better. So if you're keeping it around 5149, you're probably safe. If you literally had a service-disabled veteran-owned joint venture where the service-disabled veteran company did nothing, you could probably run into issues even though there is no regulation that says there has to be some specific work split. So I'm just looking at the question. Let's see. Let's go to the next one. Yeah, just to clarify, someone asked a question about the third bullet on that last slide. It says, JV of at least one service-disabled veteran-owned small business and one or more other businesses so long as each concern is small. That just means every member of the joint venture, unless it's in a mentor protege, which right now there really are no approved SDVOSB mentor protege programs, but every member of the joint venture has to be small under the NAICS code applicable to the procurement, not in the aggregate, but individually. And you also have to meet those other 2 requirements. For a revenue-based size standard, the procurement has to be greater than half the size standard, or for employees, it has to be over 10 million. So assuming you meet those requirements and all members are small, the JV itself will qualify as small. That's all that bullet said. Let's see, there's some other questions here. The question about transfer of ownership. If a service-disabled veteran is ready to retire and a family member is also a service-disabled veteran and wants to take over the business, how does SBA and VA verification need to be restarted, registered, from the beginning, or is there a different process that needs to be completed? Essentially, if another service-disabled veteran takes over the business, you will just have to update your profile with CVE, and they're going to want to see, obviously to make sure that person is a service-disabled veteran and other things like that. But to make the transition easier, what you might want to think about is transferring some ownership to that veteran earlier in the process so that you already provide that documentation. So when you change your ownership, you notify the VA. With SBA, it's different because it's all self-certification, so there's actually no notification that's required. You just do it, and then if someone protests you, that's when you have to deal with it. But with the VA, just make sure that if you transfer early, you can provide the paperwork to the VA in advance. The VA will already have a record of this individual being an owner, and then when you transfer the majority of ownership interest to them, it's a little bit less of an onerous process. So that's just something that we would recommend. But it really, as far as the process being different from your initial certification, it's just simpler whenever you're changing owners or adding an individual, because it's something where you just give notice and provide a little bit of extra information. Some of the questions don't, it seems like they're getting broken up. So if a couple people could send them in again, that'd be great. I can't really read them. There's one thing about, are there any decisions that a 49% minority non-veteran owner of an LLC can participate in? Meaning, will any decision requiring unanimous consent of all members be considered impermissible? The answer is no, not all of them are considered impermissible. But as you note, if it's an LLC in this question, in the LLC context, everything is impermissible, because the way the SDVOSB regs are written for SBA, it says that all decisions must be controlled by the veteran, and the way that the SBA Office of Hearings and Appeals has looked at that, which is the appellate body at SBA, they've simply said all means all. So there are cases out there where there was a supermajority voting requirement for someone to remove or add members, or to incur debt over $50,000, or to wind up the company. And OHA's opinion is basically that because all means all, if it's an LLC, you can't have any supermajority voting requirements. So that's just something to definitely keep in mind going forward. There's a question here about debt versus equity. Is it better to owe a group of investors paid back over time and leaving a JV with 100%, or to give the investment to a group as a percentage of ownership? It doesn't really matter from a certification perspective. The only thing would be if someone has a significant amount of control over you because of some amount of debt that you might owe, then that can impact you negatively from a control standpoint. So if you have a very, very large outstanding debt to one or two individuals, and depending on the terms of the note, if it allows them to call in the debt, let's say if you miss one payment, they're allowed to call in the entirety of the debt. If they can do something like that, then that might be a problem, because let's say your payment is $500 a month, and you failed to pay, and then immediately they can turn around and say, okay, you owe me $150,000 tomorrow. If you don't give it to me, I'm taking ownership in your company. That's something where the SBA would look at that and likely say that they have control over you. But other than those sorts of arrangements where they could call in the debt or insist that you pay and exercise some sort of impermissible control over your company through a financial arrangement, there really is no harm in taking debt versus equity if you want to maintain control of your company. If it's a large amount of debt, you might want to think about doing an equity arrangement, or even to make your investors happy, you could also think about some sort of phantom stock arrangement, which essentially is you don't give them any actual ownership in your company, but you give them a right to a percentage of the profits should the company be sold. That's a way you can incentivize employees, but it's also a way to kind of throw a bone to certain investors if they're in for the long haul. And with phantom equity, it's not actual ownership, so there isn't really any problem with any of these certifications or any programs. You don't have to report that to anyone or anything like that, which is a real positive. And that's not something we talk about here, but it's an interesting option, and we'd be more than willing to talk to everybody afterwards if anyone wants to discuss. Let's see here. An individual asked a question about their 100% owner of an SDVO. They want a contract with another firm as a teaming partner to meet the 51% requirement. Can they, a second subcontractor teaming partner, I'm not sure what this is, subcontractor teaming partners be employees of my firm? I think if you're asking about sort of leasing employees or transferring employees, then that is permissible so long as it's done appropriately. So let's say you have a subcontractor you're working with, and to meet the 51% requirement, you're going to take some of their employees. You can lease the employees from them. SBA takes a very close look at that, though. The key thing is that you need to control those leased employees, meaning you need to determine who you're going to hire, who you're going to fire. You need to control their day-to-day activities. In a perfect world, if you're doing their withholding and paying the taxes and things like that, that would be best, but usually that doesn't happen. And so it's the day-to-day, controlling the day-to-day activities and hiring and firing are the two key areas. Now I will tell you that VA frowns upon that more than SBA does, and we've had a couple of clients who have, I guess you call it, failed performance of work audits because of a employee leasing issue. Now, at the end of the day, the only thing that really happened is that they told them, well, we don't think this works, so don't do it again, or you need to change the way that this is operating, and that was that. So the audit didn't really result in much, but it's just something to be aware of. Okay. So yeah, there's a lot of questions here, and we'll try to get to some of them, but in order, for the interest of time, let's just keep moving on to the status protest, and we'll respond to the rest of these that we can't get to by email. So when you're filing a status protest of a service-able veteran-owned company at SBA, they're submitted to the contracting officer just like you would if you submitted a size protest to them. The contracting officer then forwards it to SBA, and SBA will review the status of the individual. Now, for VA contracts, it's a little bit separate, and Alex will get into that in a minute. But you need to make sure that you're saying more than just this company isn't owned by a service-able veteran. In a perfect world, you'd have some proof of that. You'd have some exhibits and other things to add to really show that you're not just guessing. Now, I will say I've seen more and more protests that become more and more vague, especially if they're pro se, meaning without counsel. I've seen a lot of protests filed by competitors that basically just say, we don't think this person's a veteran, or we don't think this person controls their company. And SBA isn't dismissing them as much as they should. But just to be safe, I'd still want to make sure that you're being as clear as possible, because the more evidence you show up front, the better it is, and the more likely it is that SBA will sustain your protest. This is just some information you guys can go over. It's not anything that's groundbreaking. It's more timing and what it means after a protest is filed, how things work out, what happens if SBA doesn't issue a determination. Let's say the SBA drags its feet, or they're busy because of the government shutdown or other reasons. Then the contracting officer can award the protested concern the contract, and things can keep moving along while the protest is pending. And until SBA makes a determination, let's say the SBA finds that the veteran was not eligible or something to that effect, then the CO can terminate the contract and should terminate the contract, or not exercise an option going forward, unless they make a determination that it's in the best interest of the government to proceed. And in that sort of context, there's a lot of leeway, discretion given to the contracting officer to continue. Also, with regard to appeals, this is mostly timing, issues with timing, so you know if you file a protest and lose, or if you receive a protest and are found to be ineligible. There are certain timelines you need to meet in order to file your appeal, and standards you need to meet when appealing. I haven't seen as many service-able veteran-owned status appeals recently. A lot of times the SBA, in my experience, if you show the control aspect sufficiently, then, and you have all your documentation, SBA will pretty much just agree that you're eligible, and they'll focus more on the size issues, and that's where things can get trickier. But with regard to status, things are generally pretty simple. So now I'll pass it on to Alex, and he's going to discuss some of the VA-specific issues.
Hello, everyone. Thanks for joining us. I'm going to, as I mentioned, discuss the VA-specific issues. Now, just as we've kind of mentioned, the VA program overlaps onto the SBA program. So what we're going to do in the latter half of these slides is focus on some of the differences. But you'll find, kind of as we go, that we'll mention that a lot of the standards are the same. So looking at, at the VA's program, just to, as you probably already know, it only applies to VA procurements and does not apply to generally the FAR contracting world outside of the VA, with the sole exception being the FAA, which actually has, they don't abide by the FAR. They are on a separate regulatory standard called the AMS. And in the AMS, actually in the AMS, kind of internal guidelines for the FAA, they have a guideline that says that the contracting officer will not award an SDVOSB set-aside contract unless the contractor is listed on the VA website. So that's something to keep in mind as well. We've also kind of seen generally other agencies have tried to put a VA certified requirement onto certain procurements, but that kind of opens themselves up to protest. And we have had clients that have had successfully gone to the agency and kind of challenged those, that requirement being placed onto a procurement where it's a non-VA procurement. And then the other kind of point here under this third bullet is that this applies not just to service-disabled veteran-owned small businesses, but also to veteran-owned small businesses. So really the key differences between the two is only the service disability letter that the SDVOSBs would have from the VA or from the DOD. And with the exception of that, there's isn't really any difference between an SDVOSB and a VOSB in terms of eligibility requirements. Now, generally with the application process, they've shrank it down. It used to take 3 to 6 months. And now, by regulation, it takes approximately 3 months. We have seen some delays because of the shutdown and things like that. Let's see. Okay, so turning to the next slide here. The board of directors and the quorum provisions are similar to the SBA requirements, except that they're more strict, and you see some kind of specific requirements that are set out in VA policy that are not found in the SBA. So what you will see is that the VA dictates that the veteran must directly control the board of directors. Now, that's not necessarily exactly that way in the regulations, but the VA has kind of taken that as a policy that the veteran must directly control the board of directors, where, for instance, in the case we looked at the SBA, you had a veteran who didn't directly control the board but had the ability to dismiss the entire board. That would be a case that you wouldn't fly with a VA. The VA needs that kind of direct control of the board of directors. And so when you see that kind of how that operates in practice with the quorum restrictions, that means that you can't have a non-veteran be necessary to satisfy the quorum requirements, and you also can't have the non-veteran directors, alone without the service-disabled veteran directors. You can't have them be sufficient to satisfy the quorum requirements or to vote at the board level. So, it's possible we think that the best practice would be to establish a board of directors with only one director, or at least to kind of set it out that you need the service-disabled veteran to satisfy these quorum requirements as it's kind of set up here. Okay, moving to transfer restrictions. That's something where the VA used to be very strict with kind of really requiring that you couldn't have any types of transfer restrictions that were applicable to the service-disabled veteran. And I think they've altered that recently in recent months. And now they're kind of taking the position that it's okay to have kind of commercially normal, reasonable restrictions, such as right of first refusal, tag-along rights. So as long as it's not an extraordinary, out of the ordinary type of transfer restriction, it could pass muster with the VA. Though, since this is a new position, we recommend being as conservative as possible with any kind of transfer restrictions, or if possible, carving the veteran out of any type of transfer restriction, just as a means to protect yourself if the VA is looking at this.
Yeah, which is actually, that's something we do pretty commonly as far as carving the veteran out. A lot of times at the front of the agreement or the front of the section regarding transfer restrictions, we'll simply state that nothing below applies to name of the veteran or the service-disabled veteran. And then at that point, you've exempted them out of everything, so you can be as strict as you want with the remainder of the transfer requirements because you've already stated above that none of them apply to the veteran. Now, we've had one case where the VA essentially didn't read that provision, and we had to do a request for reconsideration. So it might be easier to actually put the exemptions throughout, but you could just put it up front, and that should have the same effect.
Okay, moving to the next slide. With respect to the day-to-day involvement, business activities, here the VA has specific language that the veteran has to be, if they're the manager, they must devote full time, during normal business hours to the SDVOSB. Whereas if you're an owner, the regulations say you only need to show sustained and significant time invested in the firm, but it doesn't need to be full-time. So there's a dichotomy there where you could have an SDVOSB owner and, who's not a full-time owner, but is still putting in a sustained and significant time, whereas as long as the manager, who could be another service-disabled veteran, was working full-time. Now, when the VA kind of put these regulations into effect, it wasn't clear. It looked like they were trying to, it was put into effect like after an interim rule, and they took comments, and like on the final rule, they took out the full-time requirement for the owner, and it looked like they might have tried to take out the full-time requirement for the whole reg, but that's not the way the regulation reads now, and we've seen some rumblings that the VA is still enforcing the manager full-time requirement, and that's certainly the way the regulation still reads. So we would definitely recommend still having your manager devote full-time to the SDVOSB. Now, in terms of full-time, working for a wholly owned subsidiary can count towards working full-time, though, of course, as we mentioned earlier in the presentation, the SDVOSB itself cannot be the subsidiary because it has to have that direct control requirement. Now, we've talked about here in terms of a case where, in contrast to where at the SBA, they found that, a veteran was working in the day-to-day management of a company, even where he worked full-time at another company, which was an 8A concern. So you can see that the SBA requirements are a little bit more loose, whereas that wouldn't really pass muster with the VA. They have a more strict kind of full-time business hour requirement. So what we see kind of commonly is where, a veteran owner has outside employment or outside business interests and doesn't really submit a written statement to the VA kind of explaining that, or the veteran owner lives far away from the firm. These are all kind of issues that pop up during the application process that can reflect and can kind of blow up on you. You don't want to overlook things like what's written on your resume or your documents. You want to make sure that they kind of reflect the fact that you as the service-disabled veteran are the one involved in the day-to-day business activities. So it's just something to keep in mind when you're kind of submitting documents to the VA. Looking at the next slide, with respect to the veteran qualifications and compensations, here again the requirements are very similar to the SBA. You need to have managerial experience, but you don't need to have technical expertise or required licenses. Though the VA will question it if there's somebody who has the required licenses or technical expertise who's also an equity owner in your firm. That could be a cause of contention that could give rise to questions. So it's something where you don't need to have the technical expertise, but we would recommend, if at all possible, that you locate the licenses with the with the service-disabled veteran. Unlike the SBA, the VA regulations specifically require the veteran to be the highest compensated unless there's a business reason to pay someone else more. And what that means is if you're paying someone else more, when you put in the application with the VA, you should submit a written statement kind of explaining that and justifying why it is that the veteran is not the highest compensated individual. Looking at significant business relationships with other firms, here again, similar to the SBA, for the VA, they're going to look at whether or not there's a significant business relationship. You see that a lot with if there's a former employer who has some sort of ties with the SDVOSB, that's going to be something that's going to create some questions. Let's see. It's going to look into the degree of dependency. It's a little bit similar to the SBA's affiliation analysis under its economic dependency affiliation. They're going to kind of look at the degree of intersection and dependence between the two firms. So the key is kind of whether or not the applicant is able to exercise independent business judgment on its own. So in terms of setting up, so looking at the next one, community property, here again, the VA has kind of specific rules about community property that you just have to keep in mind. If you live in a community property state, you need to be aware that the VA kind of looks at community property and assigns, if there isn't some reason like a transmutation agreement saying where you have your spouse, if your spouse is not a service-disabled veteran, saying, she doesn't have or he doesn't have an ownership in the SDVO, there's a possibility that the VA could say that your ownership interest is diluted because your spouse, under this community property law, owns 50% of the company, and that can influence whether or not you have the necessary amount of ownership interest in the company. So it's something that you just need to protect yourself with the VA by kind of exercising the correct agreement just to kind of dot the I's and cross the G's. So just to kind of give you, the community property states are Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. And Puerto Rico is a community property territory. Okay, so moving on to trusts, we kind of discussed that earlier. It's similar to the SBA where you can have a trust as an owner, but it has to be revocable, and the veteran has to be the grantor or the sole beneficiary. You have to be very careful in kind of setting it up just to make sure that these kind of provisions are very clear that the veteran is the one controlling everything. Let's see. And let's go to the next slide. In terms of joint ventures, under the VA's requirements, you have to satisfy all of the SBA requirements that we set out earlier, and in addition to that, the joint venture has to be separately verified and listed in vetbiz.gov. So you need to get that separate verification from the VA as well, and the joint venture has to be its own separate legal entity that's majority owned and controlled by a verified SDVOSB. So it's a number of hoops to kind of step through that you don't have to step through on the SBA side. The key here is to not file kind of simultaneous applications for everything all at once. You kind of have to step through the hoops one at a time. You get the joint venture approved, you have to set it up and have it as its own legal entity. It just kind of makes sure that you don't try to do everything all at once.
Yeah, and just to clarify, under the SBA's program, whenever we say legal entity, a joint venture for SBA doesn't actually have to be a legal entity. It does for the VA. And that means for SBA, you could form a de facto partnership where two companies come together by contract to be a quote-unquote joint venture, even though they didn't form a separate LLC or some other entity. Now, in reality, for taxes and other things, that would be treated as a partnership, so it essentially is an entity, but it's not registered with a state or legally created. So SBA, you can do that. You can do a joint venture by contract. The VA, you can't.
Looking at enforcement, unlike the SBA, the VA has the ability to conduct on-site examinations, which they can do on a random basis, or they can do if they receive credible information. The key with on-site examinations is just to make sure you have all your ducks in a row, all the records are being stored at your principal place of business, and you're kind of meeting all of these requirements and are prepared in case they do show up. Now, they also have status protests, and these largely mirror the SBA procedures. Let's see, the protest decisions must be filed within 21 days, and then the contracting officer can award a contract if no decision is issued within that time. Moving to the next one. There's been a new rule that has kind of amended the VA protest procedures, and the new rule says that denial decisions on the basis of a failure to meet service-disabled veteran criteria are not appealable. Now, you can protest if you can file a written appeal of the status protester with OSDVU, and then once you go to there, you don't have any more avenue after that. Let's see. So if there's a decision, it's effective immediately. So if the contract has already been awarded, the awarded contract shall be canceled, basically be deemed void. If it hasn't been awarded, then the appeal decision will apply to the pending acquisition. And once you're deemed ineligible, you can't submit another offer as an SDVOSB on a VA procurement unless you successfully appeal the determination or if you receive a new verified status. So looking at kind of what's coming down the pike in terms of new regulatory changes, we've seen there's been a new rule that has, in addition to changing the name of CVE, it's still called CVE, but it's now called the Centers for Veterans Enterprises, I think. Actually, it might be a little bit off on that name. That it's issued a new rule confirming that firms have to re-verify every 2 years rather than annually, so that kind of reduces some of the onerous task of verification down. There's still no interagency agreement with the SBA in terms of adjudicating status protests by the SBA, so that means you still have to go through the VA procedures. And additionally, the CVE has said you have to be small under each NAICS code that you have listed on your VetBiz profile. So in August, they kind of sent an email saying that within 30 days you have to take off all of the NAICS codes on your profile that you're no longer small under. Let's see. As we kind of mentioned, they're getting more lax with transfer restrictions, and they're considering a rule change that would permit transfer restrictions, such as we've been talking about. There's also a recent bill in the House of Representatives, it's still in committee, but what it would do is it would consolidate the definition of an SDVOSB and place the responsibility for the administration of the program with the SBA, which would really reduce a lot of the inefficiencies. That's still in committee, and we haven't heard anything in terms of whether it's been reported out of the committee. But it's something to keep an eye on because the SBA operates the whole SDVOSB program a lot more efficiently than the VA, so it could be a way to kind of get the whole programs more efficient. Now, what are the consequences of misrepresenting your status? There's a new rule about the presumption of loss, which says there's a presumption of loss equal to the total amount expended on the contract or subcontract or agreement whenever you're found to have willfully misrepresented your status. Obviously, that's a very draconian rule. When there's a carve-out here, a limitation of liability, that it doesn't cover unintentional errors or technical malfunctions or anything that's not an affirmative, intentional, willful misrepresentation. And nonetheless, it's still very scary that you kind of have this entire presumption of loss rule. So it's something that people have been very concerned about recently. So if you can show you're in good faith, there's certain things that they'll take into account. They'll look at your internal management procedures. They'll look at the clarity or ambiguity of the requirement. They kind of look at the efforts you made to correct any errors or misrepresentations. They'll all kind of weigh those factors in determining whether or not you were acting in good faith. And of course, you could be suspended or disbarred if you're found of misrepresenting, or you're found to, you could be subject to False Claims Act liability, as you could with any kind of other representation you'd make on these types of programs or contracts. And that's it, I guess, and we'll try to answer a couple questions if we have time right now. I should also mention we have another webinar coming up in January on small business affiliation. Let me hand it over to Sai.
Yeah, so thank you, everybody, for coming online, listening to us this afternoon. Looks like we are out of time right now, but we will follow up with everyone who asked a question, and we'll do it by email and get to everybody in the not-too-distant future, next couple days. And we'll make sure that everyone has their question answered, and if there's any follow-ups or other issues, Alex and I will be happy to talk to you. Our contact information is on the last slide, which is up right now. And again, thank you for attending, and hopefully you guys learned a few things, and we'll be happy to talk, answer some questions if you haven't. Thank you.